is now in session.
Thank you. All right. We are here today on our case number 1CA SA160096, Phoenix Newspapers, Inc. versus Reinstein and Moran. As counsel know, each side's allotted 20 minutes for the argument. The petitioner may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve, you're in charge of keeping track of your own time. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium and each time, we'd appreciate it if you would give us your name and the name of your clients. We have read the briefs, we've studied the record, and we've also discussed the case in our conference. So with that, Mr. Bodney, proceed.
Good morning, Your Honor. For the record, David Bodney, and with me is Heather Horrocks on behalf of the petitioners, Phoenix Newspapers, Inc., and John Deanna. May it please the Court. And I would like to reserve, if I may, 5 minutes for rebuttal. A criminal defendant wants to compel disclosure of a reporter's confidential notes of interviews with a surviving crime victim based on nothing more than the defendant's speculation that the notes might be more useful to the defense than the 2 published news articles the defendant already has. This defendant, accused of first-degree murder, murdering 1 priest, and assaulting a 2nd priest with a deadly weapon, wants to rifle through the reporter's notes as a backdoor way of getting his hands on the surviving victim's statements in violation of both the reporter's privilege and the victim's rights.
The source, I mean, everyone knows that we're talking about interviews with Father Terra, and there's a reporter's privilege only apply to confidential sources.
Your Honor, the reporter's privilege in Arizona, as the 2 cases that have touched on it have said, protects both confidential sources and materials.
But the statute only talks about sources, correct?
The statute uses the word sources, but it does not say identities. And
then how is there a privilege then?
Your Honor, I think it works like this, and it has to work like this, because, for example, here there is a source, a priest, a victim, who speaks with a reporter after they develop a relationship of trust. And the source tells the reporter, I'm going to share some information with you in confidence. And the reporter agrees. Other information is not shared in confidence. If the reporter's shield law is to have any meaning, it must mean, as both Bartlett and Matera have indicated it does mean, that both confidential sources and materials are protected because there's no way to reveal the confidential information in this instance, a common instance, without also revealing the confidential source or the source's identity.
Bartlett and Matera, that's loose language, maybe, because the issue here wasn't raised in either of those cases. Moody summarily disposed of the shield law argument, although it's kind of a little confusing because the court talked about reporter's privilege and then talked about the shield statute. Perhaps the court conjoined the 2 by saying, since there's no confidential source, the privilege doesn't apply. Why isn't that the best guide for how we should interpret the statute?
Well, Moody is not a case, Your Honor, that begins to interpret the Shield Law. That isn't what the case is about. And it is a case that involves very different facts. But importantly, the court does affirm the trial court's decision to allow testimony by the reporter, to allow cross-examination of the reporter to authenticate the story. Biggest difference between that case and this case, Your Honor, is the defendant was the interviewee in Moody. And so there was no confidentiality whatsoever. The defendant had talked on the record to the reporter. The reporter had been called as a witness. I'm not sure there was any objection to his testifying to simply authenticate a news story that appeared in the Tucson Citizen. And the question really was whether the lower court had appropriately limited the scope of the defendant's cross-examination of the reporter by limiting the cross-examination to authenticity. And to read directly from the case, it says, there's no abuse of discretion where the trial court limited cross-examination of the reporter to, quote, questions that probe the veracity, accuracy, and authenticity of the statements made by the defendant. And the court, quote, expressly precluded any questions about unpublished information or about repertory or editorial processes. That's a huge difference. I mean, a very big difference. So I think that comment about confidentiality was made in passing because that's the obvious issue. The confidential source is the obvious case. But what we have here beyond 122237, the Arizona Shield Law, is ARS Section 12-2214. And in our review of all the circuits and the various shield laws, Arizona is unique in having ARS Section 12-2214. And it was passed by the legislature following the Brandsburg decision, and it incorporates in the statute certain language that must be the subject of a required affidavit. And so I think even if I think it's essential to protect the confidential information. That is the essence of 122237. And it is because without it, the First Amendment freedom of speech and of the press is sacrificed hugely. Reporters are not going to trust or not be trusted by their sources. Reporters will not be trusted by their sources if cavalierly, as one court said, routinely, this kind of information can be made available.
Counsel, let's look at the First Amendment analysis on this. One of the requirements under the Schoen test that we have, Schoen 2, is non-cumulative. My understanding of the record is there were statements made by the priest to the police. There was a 911 call, and then there's the published articles that have some quotes. I believe the defense theory is here that something in those articles alerted them to there was some different or additional information in those quotes in the articles than one had already been disclosed in prior interviews or prior information. Do you agree with that, or is it pretty much the same information?
Judge Gould, I completely disagree with that, and here's the reason why. There are two published accounts, and let's be clear about these important facts. John Deanna, the Republic reporter, is not a precipient witness. He didn't witness a crime. This is not like Brandsburg, where you've got a grand jury subpoena and a reporter resisting a duty to testify and come forward with his evidence. After developing these relationships of trust, he conducts an interview 1 year after the crime and a year and a half after the crime. The second story published on Christmas Day last year. The statements, there is no evidence, I've not seen it, we didn't see it in the affidavit of counsel, suggesting that there's any reason to believe there would be anything in Mr. Deanna's handwritten notes. This is not about a transcript. It's not about a tape recording. This is about the mental impressions, the notes jotted down by the reporter from which 2 news articles were created, would differ in any way from the news articles. This is important too. My client isn't the state of Arizona. We don't have some sort of disclosure duty, even if there were one, which I don't think there would be, but we don't have a duty to share handwritten notes of an interview, part of which involves the exchange of confidential information. Those are all, I think, very critical facts.
Isn't, though, the assertion by the newspaper that the notes contain confidential information a concession that they contain information that's not in the stories?
Your Honor, the only information we know that would not be in the stories is confidential information protected by 122237.
So there is information in the notes that's not in the stories. It's not in the stories because it's confidential.
But, Your Honor, this is critical. There is no showing of materiality.
Right.
None. And I apologize for interrupting, Your Honor.
What must the defense do to make that showing in a situation like this?
Well, the statute says the burden rests with the defendant to demonstrate relevance and materiality. And if we go back to the test, it's probative value versus prejudicial effect. We know that large swaths of the article are not even material, much less relevant, because they deal with 2 priests during World War II and their decision how to deal with criminal acts at that time. They deal with love. They deal with faith. They deal with redemption. They deal with the size of the congregation. They deal with a priest wrestling with a crime a year after it happened, and all of that is in the story, and none of that is even material. The hope is, I'm sorry, Your Honor.
The concern, as I understand it, though, is how is Mr. Moran supposed to show that the confidential material is material if he can't ever see it?
Well, Your Honor, Judge Howe, there ought to be at least some threshold showing that, other than the fact the reporter used quotes for some statements and didn't use quotes for others, that there's some variation between what's in the notes and what's in the story.
Isn't the missing piece here the in-camera inspection? Shouldn't there be an in-camera inspection? I mean, on the one hand, you have defense counsel trying to represent their client's Sixth Amendment right to fair trial, due process. They see there's an interview that deals with a material witness. There are statements in there that deal with the crime itself, but that's not sufficient to show there's actual relevant information there. But it's some bearing on the case. Isn't the next step then to have the trial court review it in camera, or the special master review it in camera?
Your Honor, we mentioned the possibility of in-camera review, which is something the lower court just rejected out of hand. I have no way of knowing, but to answer your question, we would resist in-camera review as part of Your Honor's review of this case for a couple of reasons. The first, the most practical, is we may be right back up here. This could be the Arizona version of Shown 1 and Shown 2, and if we can avoid judicial ineconomy or diseconomies, we should try to do that. Second is, there is a kind of offense, and cases have referred to this, whenever confidential information is shared by a reporter with anyone, even with a court. It can happen. It's been approved. There's one interesting case cited by this court in the Flores decision from the Supreme Court of Wisconsin. And that case, let's see if I have the citation handy. I can get it for my rebuttal. It's the Green Bay newspaper versus circuit court decision. That court rejects the in-camera review and actually finds a qualified privilege based on the Wisconsin Constitution, whose language is, in all relevant part, identical to the Arizona Constitution. It really does seem to me that there are some threshold showings they need to make if they're going to rifle through the files of a reporter. One of them is some basis other than rank speculation that the reporter's notes differ in some relevant way from the story, apart from the fact that they contain confidential information.
So they need to ask Father Terra if he'll be interviewed.
Your Honor, that's
At a minimum.
At a bare minimum, the source of the information is Father Terra.
What's your response to the argument, and we're going to ask counsel about this, that the information is not Father Terra's statements, but it's the notes?
Well,
Fine distinction.
Well, Your Honor, I'm not sure how they can meet a threshold showing that a reporter's notes of conversations he had with a crime victim a year and a half after the crime are somehow relevant just because they exist, because there's been a newspaper article or two, and some of the words are in quotes and some of them aren't, and maybe his statements have changed, but there's no evidence to suggest that the notes would reflect any change in what he said. They have the articles to cross-examine Father Terra with if ever he takes the stand.
Well, but there are statements, or could be statements, in the confidential notes that were jotted down by Mr. Deanna that could be used for impeachment purposes. And having Father Terra recall later what he said in the interview, how is that sufficient to allow impeachment?
Well, Your Honor, the first thing is they have to ask Father Terra if he will be interviewed. That's clear from the media subpoena law, and they haven't done that. And if Father Terra can answer those questions...
How is a subsequent interview the same as the information that would be contained in Mr. Deanna's notes?
Your Honor, I see I'm running low on time. I do want to answer the question. I think the analysis is really the probative value of these notes versus the prejudicial effect, and the court must take account of the privilege. And the privilege asks the question, if a criminal defendant can come in on facts as thin as these to say, I want to see the reporter's notes because I think maybe there's something that's good for me, that turns the reporter into a litigation consultant for the defendant, and that's precisely what the media subpoena law seeks to avoid.
Counsel, is the relevancy standard the Rule 401 and 403 standard you've just recited, or the relevancy standard for discovery? In other words, anything that could lead to the discovery of admissible evidence. Are you putting too strict of a relevancy standard on the showing?
Your Honor, I'm not. Schoen makes it very clear that it's actual relevance, not potential relevance.
Admissibility.
That's right. And so there's no showing of actual relevance here. That is what Schoen says unmistakably. I see I'm down to about 2.5 minutes. Unless there are other questions for me now, I'll take my seat and
Thank you.
let Mr. Moran's counsel take the podium. Thank you.
Thank you. Ms. Walker.
Good morning. I'm Angela L. Walker, here with Bobby Falduto, who's lead counsel on behalf of Gary Michael Moran. In this death penalty case, Mr. Moran is fighting for his life. Father Terra, who is the only percipient witness to the events that occurred, gave a detailed summary of events to Mr. Deanna that included what occurred and his feelings of forgiveness to Mr. Moran, and did this knowing it was for publication.
And all of it was published in the newspaper, Counsel.
That is exactly right. It was published in the newspaper. However, Mr. Deanna is the only person who has the statements given on those dates in preparation for the interviews.
But what's not disclosed about the crime? It's published in a newspaper.
Because the information has not been provided in Mr. Deanna's affidavit, Mr. Moran does not know.
What information? Do you know?
Confidential information.
Okay. I mean, simply because it's confidential information, therefore it's relevant. Is that what your argument is?
Essentially, yes. The threshold is...
Then what reporter's privilege is there? Could there ever be a reporter's privilege?
Well, going to the reading of the reporter's privilege under 12-2237, it says...
What about under the First Amendment? I mean, how can that argument be so? If simply because it's confidential, you don't know what the father said to the reporter, you're entitled to get it.
The long history of case law supports that, Your Honor.
I'm not aware of any case law that says just because it's confidential, without showing that it's relevant or it's non-cumulative, or I don't know any case law that supports that. I mean, counsel, I'm not trying to be too hard on you. I understand. We all understand this is a death penalty case and you're trying to get information, but there is a privilege, and simply because it's a death penalty case, that does not wipe out every privilege that exists just because it's a death penalty case.
Your Honor,
The First Amendment doesn't disappear simply because it's a death penalty case.
in the cases that set forth any privilege have a weighing. That's clear from Justice Powell's concurring decision in Brandsburg. Justice White's decision, this is regarding the First Amendment privilege. Justice White's specifically said there's only one constitutionally guaranteed privilege, and that's the criminal defendant's Fifth Amendment right against self-incrimination.
And that's an absolute privilege. This is a qualified privilege. I understand the difference.
Correct.
And so, hence, it's a qualified privilege. There are exceptions to it, and there are weighing considerations. There's no weighing consideration a court has in terms of Fifth Amendment. Defendant invokes a Fifth Amendment right to silence. That's it. There's no weighing. But that doesn't mean that this privilege doesn't have constitutional dimensions. I mean, what is it specifically in the article that you saw that was different from what had already been given in the statements to the police or in the 911 reports? What was it that clued you in where you thought the statements that are being given in this article are different or contradictory in some fashion? Is there something you can point me to?
Yes, Your Honor.
Okay.
The first would be that Father Terra had a conversation with his brother in the hospital. And during that conversation, he discussed possession of the gun. And at that particular time was the first time he denied ever firing the gun. Prior to interviews, and I don't believe that this is in the record.
Well, if it's not in the record, counsel, it's impossible for us to consider that on appeal.
What is in the record, and that is more or less undisputed, is that there were statements that were given that are inconsistent with prior statements. And the reason would be is that Father Terra sustained quite significant head injury, and his statements evolved over time. That is in the record, that we set forth that information.
That in the affidavit? The subpoena affidavit?
In my specific affidavit?
Right.
Not that he sustained a head injury, no. But what we...
Were there any specifics in the affidavit in terms of what you saw as inconsistencies or possible additional information that was disclosed in the published articles versus what had already been disclosed in statements to the police?
Not in the affidavit, no. But there...
Why shouldn't, speaking about the statute, the subpoena statute's requirement for exhaustion and the requirement under the case law interpreting the First Amendment's reporter's privilege to the same effect, why shouldn't a defendant in your client's position at least call up the interviewee and ask him whether he would talk?
That's not required, because the interviewee could not possibly provide this exact statements made in preparation for the interviews. Cuthbertson, cited by both PNI and I, goes into detail about the uniqueness of statements being frozen in time. And that was a criminal case as well, where the...
If that's the case, then all bets are off. You always get them. You always get the notes.
I would not disagree with that. I think that's accurate. There's two...
Well, that's assuming that Mr. Deanna, assuming the statements were made, and assuming that Mr. Deanna recorded those statements, that still assumes that that's accurate, that Mr. Deanna accurately took down whatever statement was made.
That's a concern that will always be made, specifically when a victim gives an interview to the prosecutor, and it's not, the prosecutor, but the police, and it's not recorded. A police officer records, based on notes or memory, what the witness said. That doesn't mean that that's then prevented from giving to defense counsel or the person defending against charges, because they can't then use exactly those words. What would happen in that context is that the witness would say, I disagree with how my statements were recorded, but we would still have the ability to use those statements. The materiality and relevancy here is we have nitty-gritty details of how this crime occurred. And what's, going back to Judge Gould's, there's additional information that wasn't provided, not specific to the events, but given that this is a death penalty case, there's mitigation and aggravation. And the importance is that Father Terra, for the first time, talked about feelings of forgiveness towards Mr. Moran.
Why can't you, Ms. Walker, why can't, when he testifies in the sentencing phase, why can't you bring up the article and say, you mentioned forgiveness in this relationship, why can't you question him about that? I mean, you have a published article to question him about his statements. What is it that you think you have to have in the confidential information that you just don't know, right?
But if the analysis is we can't ever show because we're not going to tell you, that means that there would be an absolute privilege.
No, I'm not saying that.
Okay.
I'm certainly not saying that. I'm saying you have to show something. Don't you concede that you have to show something other than we know there was an interview and that was something was discussed about this crime, therefore it's relevant? I mean, do you think that's all you have to show, or do you have to show maybe something more than that?
Under the media subpoena law, I believe that's all that needs to be shown. The contention would first be...
What about under the First Amendment?
I believe that's the correct under the First Amendment as well. The First Amendment in Ray grand jury proceedings, the Sixth Amendment, the Sixth Circuit case dealt with this. Cuthbertson from the Third Circuit dealt with this. They were very similar. They're witnesses to a crime that gave interviews to the media. The defendant sought that information and the court disclosed it, saying that what they talk about in regards to a criminal proceeding must be disclosed because the defense, the criminal defendant's rights are actually constitutionally bound. There's no case saying that the reporter privilege, and the fact that it's a privilege, that doesn't make it constitutionally bound. It is a privilege supposed to be reflective of the goals and the spirit of the Constitution, but it's not
prophylactic
intricately
measure to ensure those rights, just like Miranda is not of constitutional dimension, but it protects your right to counsel. It protects your right
Exactly.
to remain silent.
That's exactly right.
But it's still significant to protect those rights. Can I ask a question? Did you oppose the in-camera review of these documents?
Yes, Your Honor.
Why?
The in-camera review threshold analysis should start with whether a privilege exists. Mr. Deanna has, and PNI has argued that reading into 122237 is it protects source of information and the information. Those words and the information are not in 122237. Two cases additionally, Matera and Bartlett, both take that head on and say that, and those are...
That wasn't raised in those cases.
I believe it was, Your Honor.
But Bartlett was a videotape of the incident.
If I may, Your Honor, I would quote where Matera specifically said it protects the media from being compelled to testify or otherwise disclose confidential sources. The statute does not protect any and all information gathered. Right. That is direct.
Deal with confidential. The issue there was not confidential information. So
I would direct the court to Flores. In that case, the court gave an order sealing documents and the media was given the documents not to be published. Later, the media published those documents. There, the court, even when we had a confidential source, which we do not have here, the court did entertain having that confidential source revealed to protect the defendant's rights. That's what that whole litigation was about. That's the case that sets forth doing the in-camera review. But here, the court, in order to find that in-camera review was necessary, would have to show that there was a privilege that attached to begin with, either derived from the statutory language or would be an extension by case law.
What about the First Amendment privilege?
The First Amendment is a qualified federal reporter's privilege that will give way to a criminal defendant's constitutional rights.
But why didn't the First Amendment privilege implicate a suggestion for, or justify a suggestion for in-camera review?
Because the question is whether, if the privilege exists to protect information, that's when an in-camera review would be done. For instance, you have a personal injury lawsuit. The medical records of somebody who is injured may be subject to disclosure so that they can determine whether there's anything in there that would be helpful to the defense. But that doesn't mean the entire amount of the records are needing to be disclosed. But that's because the other records are having confidential protected health information under HIPAA. We don't have that here. There's no statute that explicitly gives information protection. And additionally, even if there was confidentially given information, I cited the Catrone case. The Catrone case is very on point, recognizing a difference between a privilege and something done with confidentiality. And even when in Catrone there is confidentiality derived from statute, it could be pierced, because there could be and was there a need outweighing the confidentiality. That was in regard to medical records. There's no reason why that wouldn't also be the analysis here, even if the court were to accept as true that the statute protects that.
But why isn't all of that easily addressed with an in-camera inspection? The court looks at it. The argument from the newspaper is it's confidential, and this is probably why Mr. Bodney objects to the in-camera inspection. And the court decides, well, this may be confidential, but it's relevant and it needs to be disclosed. Why can't all that take place within the in-camera inspection?
For two reasons. First, the court would have to decide, which Judge Reinstein did not, was that there's any privilege protecting that information. Only upon a finding of the privilege protecting it would you do an in-camera review.
And if we found that there was a privilege, would you be okay with in-camera review at that point?
The difficulty would be if we did do that, it would need to be ex parte. Mr. Moran is actively...
You have a special master for this case? Hasn't the court appointed a special master, mitigation master in this case?
No.
I'm not aware of what a special master would be.
I mean, usually in capital cases, doesn't the court appoint a special master or another judge to handle all the ex parte mitigation requests in Maricopa County?
I'm not aware of that procedure. Typically, we go before the trial court judge.
Well, I mean, I've done capital cases, and I mean, I thought that was pretty standard to do that. But I mean, could you do it in that fashion? I understand some of the concerns about having the trial judge maybe get involved in it, but ask the court to appoint a special master for mitigation purposes, and that way you can make the requests in an ex parte fashion, right?
There may be a procedure set up, but the problem would be that Mr. Moran, during active investigation, would have to provide the nitty-gritty details of where he is going, and I can avouch to the court that there is extensive investigation being done. What the court would be in a position of knowing is...
You're concerned about disclosing work product in the defense and so forth, but that's, I mean, I'm just saying, that's usually why the special master is appointed in capital cases. It's just a suggestion.
And I agree with the court's suggestion. I think I'm not being articulate in my point. I'll get to it much quicker, which is that the scope of a capital case is incredibly large, and for a trial court judge to be in the position of having to determine what is relevant and not would put that judge in whenever this is an issue, in the role of having to get into the nitty-gritty defense investigation to make a determination about materiality and relevance. What may appear to be not relevant to a judge may be absolutely relevant to Mr. Moran. There needs to be a function of how Mr. Moran could convey that, or else information that could be critical, because this is literally his life on the line, may not be perceived by that judge, and Mr. Moran would miss that ability to develop that investigation and that mitigation.
I suppose that rationale could apply to any in-camera inspection, though, counsel. At some point, there's a system. We've used these in-camera inspections for years to go through medical records, all kinds of confidential information.
I agree with that. Again, the threshold would be whether there's a privilege that exists. The court would have to read into 2237 that information is protected, and then additionally find that that protection is absolute, is not subject to being pierced, because there is long history, especially set forth in the Catrone case, where the statute and the legislature protects confidential information, and is allowed that in those cases it's allowed to be pierced, even in a personal injury where there's no constitutional dimension involved.
But counsel, there is a First Amendment privilege that's separate from the reporter's privilege here, and regarding that and the media subpoena law, you have to show that you can get the information from any other source. And what I'm concerned, I understand your argument, but what I'm concerned about is in this case, and in any case, you can so define the information that the person is asking for that you could never get it from an alternate source. And I like your answer to how that works in Germany, how that works here. If Father Terra honestly told you, if he were interviewed, here's exactly what I said to Mr. Diana, isn't that good enough? Isn't it good enough? I sense your answer would be no.
It's not, Your Honor. And the reason being is that it's not, unless there was a recording done in that interview, which has not been alleged in the case, there's no way for Father Terra to remember what he told a year and a half prior. Even if it was a day later, the ability to recall exactly what was said becomes incredibly challenging. It's just like if you were to come home from work and tell your partner about the day, you're going to leave out nitty-gritty details of maybe a conversation you had. It's not necessarily. I'm sorry, Judge Johnson.
Well, but doesn't that argument effectively make the reporter an agent of the prosecution or an agent of the defense? I mean, it's one thing to say Father Terra sits for an interview, says, ask me anything you want. I'll answer honestly. And my memory is just as good now as it was 6 months ago when I was interviewed. You're going to get fairly what you're entitled to there. What you're not entitled to is, what did you tell the reporter? What did the reporter ask you? Isn't to get at the second, the latter question seems to me to just make the reporter your agent.
The difference is that we are not seeking from Mr. Gianna, what did you ask Father Terra? We were asking what Father Terra said. And Father Terra may honestly, truthfully believe that he can recount exactly what was said. But there's the frailties of the human perception and ability to recall memory. Father Terra's is less in this case due to damage, and that is in the articles. He talks about the memory being not the same and that he slowed down in his injuries. So even assuming the best case scenario, Mr. Moran would be having to hang his hat on Father Terra being confident in his ability to recall, but that's not preserving Mr. Moran's constitutional rights to impeachment as recognized.
Well, and counsel, even given your client's constitutional rights regarding impeachment, does that is that right so strong and so particular that it has to be exactly jot and tittle of what was said? I mean, I would think that in any criminal case, and I did criminal appeals for 25 years, that is quite a lot to ask, and I'm not aware of any case that says that the defendant's right is that strong or that particular.
I'm out of time. May I answer?
Please.
There's two considerations. One is that this is not your average criminal defendant. This is a capital defendant who is subject to heightened scrutiny. And when there's a question, the case law supports that he has the ability, or it cuts it the way of the capital defendant. But two would be, yes, that the exact statements in a case where the only witness to what occurred has that, the ability to recall, it goes to reliability, credibility, consistency, the ability to do pretrial defense investigation, and for Mr. Moran to prepare for his fight for his life, quite literally.
So I'm sure you don't mean this. I'm just clarifying. You're not saying that because your client is charged with capital murder, his right to impeachment is somehow greater or stronger than a defendant who isn't charged with capital murder? Or are you saying that?
In a context where you have an open question, I am saying that, Your Honor. Yes, under the Quarterman case that I cited in my response.
Is Cuthbertson the best case you have for the notion that the defense's need for impeachment evidence would overcome the reporter's privilege under the First Amendment?
Yes, Your Honor. And in Cuthbertson, it wasn't even the only percipient witness. It was witnesses generally. It was, I believe, a fraud investigation. So even the interest in getting those witnesses information about what happened and what they told the media would be less than in a case where it's not only the capital case, but it's the only person who could be compelled to testify about what occurred.
But in this case, if Father Terra on the stand is shown the articles, and he says, yes, I said that, yes, I said that, yes, I said that, what would you impeach him about?
In Arizona, we recognize the ability to do pretrial investigation. That would include being able to prepare for a defense interview. In Arizona, that's also a protected right for pretrial investigation and interviews. The reason that the defense has not requested an interview is because we're not done with investigation about the scene, the forensics and the crime scene reconstruction, to be able to even be in an adequate position to interview Father Terra about what occurred. But the ability of getting that pretrial is important, because if Father Terra were to deny it, well, there's two scenarios. First, Your Honors, if he says, yeah, that's what I said, no harm, no foul, because there's no need for impeachment. He's adopted those statements. Oh. But if he were to say no, Mr. Moran he could say that reporter got my information wrong.
Well, then why don't we have the discussion then?
The reason you wouldn't have the discussion then is going back to the pretrial investigation rights to preserve Mr. Moran's federal and state due process rights to pretrial investigation. Father Terra being the only witness of what occurred in that room that could testify, as well as how many times he's provided interviews and the differences in the interviews, specifically in the record. It's dealing with what would potentially be round two, but it is in the record because P&I attached it, would be information he gave subsequent to this line of litigation in Texas in interviews, where he provided more information about the time of Father Walker's death that had never been previously heard before. So in a situation like that, Mr. Moran, if that were to have come out on the stand, there's no time to get independent medical examiners or other people to really evaluate that situation. So it's going into the pretrial right to defense investigation. I'm sorry how long-winded that was.
But it sounds like this may be premature, because shouldn't you, if if you're correct in what in your view of impeachment, don't you first need to talk with Father Terra? And that's something that I heard you just say you haven't done that because that's not how you've set your investigation schedule up. Yeah, so
Right.
shouldn't we be having this discussion later rather than today?
I don't believe so, because there's clear that the media subpoena law sets forth the materiality and relevance showing. If P&I's reading is correct, that any person seeking this information has to show what is in those notes prior to receiving it, then the media subpoena law is worthless, because no one would ever be able to be in a position, and it would be speculation. The importance is you can make a showing based on what is known. And what is known is we have paraphrased statements that are not exact words of Father Terra that Mr. Deanna wrote. That in and of itself is getting us the ability to get into those statements.
Okay. Thank you. Okay. Thank you very
I
much.
apologize for going over my
No,
time.
we asked you questions. We wanted to hear it, so thank you.
Thank you.
Mr. Bodney.
Your Honor, if I may, I'd like to try and distill what we've just heard down to three basic points. The first concern I hear is that there are no outer boundaries to the defendant's position. If the defendant's position were adopted by this court, the qualified privilege under the First Amendment, the media shield law, the media subpoena law would be dead letters. They would not be effective. The second point I'd like to get across, and I talk about them briefly if I may, is a fundamental misunderstanding not only about the way this basic act of journalism works, but what's at issue in this case. We keep hearing about the right to get verbatim transcripts, as if Mr. Deanna's handwritten notes are the best evidence of what Father Terra said to him that couldn't be found in the articles. Well, the reality is, these are not verbatim transcripts, and we made that clear to Judge Reinstein not once but twice, and he wouldn't hear anything of it. These are simply notes. Cuthbertson is their best case. United States v. Cuthbertson says two things of relevance. One is, in summary, we hold that journalists possess a qualified privilege not to divulge confidential sources and not to disclose unpublished information in their possession in criminal cases. And it goes on to point out that the only item of interest for a possible in-camera review were the verbatim statements, verbatim and substantially verbatim statements. At a minimum, it would seem to me that the defendant simply needs to come forward and say, there's some reason to believe that these two news articles have behind them in the reporter's notes something relevant other than information you won't produce because it's confidential. Judge Gould, that's precisely the point that you asked counsel about, and she essentially conceded, I think, if it's confidential, then, there's no privilege. Where do we go from there? There's no outer boundary. My third and last point, if I may, relates to the in-camera review. At this juncture, there are a number of ways the court could go with this case. I promised to provide a citation to the Wisconsin case where it found, as a matter of its state constitution, a privilege. That's 113 Wisconsin 2nd 411, State XRL Green Bay Newspaper Company versus Circuit Court. And that's one approach, and it's not true that we mention that case only in the special action paper. We mention Article 2, Section 6 in our motion to quash the subpoena before the court below. One approach is to say that Article 2, Section 6 forbids this kind of discovery by a defendant, and it is not proper to simply invoke the fact that your client is accused of murdering one priest and bludgeoning another, a 6-felony count complaint, and that somehow entitles you to convert the press into your litigation consultants, because it would be nice if you could review our notes first. I heard for the first time today that what they learned from somewhere is that Father Terra had made a statement to a brother. well, interview the brother, or ask to interview the brother if he's a victim under the Victims' Rights Act. Make some of these threshold requests. None of that has happened here. So there's the First Amendment qualified privilege. There's the vital Arizona Constitution. ARS Section 12-2237 has been interpreted, at least in passing, both times by this court as protecting confidential sources and information. And then there is the media subpoena law, which asks them, doesn't ask, it says the defendant shall produce a required affidavit that sets forth each item of information sought. Not you had notes, and even if you get every tot of information, every jittle and tot of the information, that's not like saying you're getting a verbatim transcript. You're getting mental impressions of what the reporter recorded a year after their crime was committed. So for those reasons, we think we might very well find ourselves back here. It would not be a terribly efficient use of judicial resources to send it back for in-camera review where the record is so devoid of compliance with either of the two statutes or the two constitutions at issue. And if there were in-camera review, I must say it would have to be not only in-camera but ex parte, because that is the risk of the reporter sharing confidential information with anyone, even me. And speaking of judicial resources, thank you, Your Honor, for this time. And
Thank you to all the lawyers for your work on this case. We appreciate it. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.